We give attendees a moment to join. Welcome, everyone. This is the meeting of the Family Law Subcommittee of the California Paraprofessional Program Working Group. I'd like to start with a roll call. Bashan?
Present.
Hamilton?
Present.
McRae?
Present.
Olvera?
Present.
Sarouche?
Here.
Great, thank you. So it sounds like we are all here and we are ready to start. I'd like to invite anybody who wants to make public comment. We have a number of attendees. If anyone is interested in making a comment, please raise your hand using the function in Zoom. I'll give people a minute to indicate if they want to speak. Seeing no one at this time, I'd like to welcome our guests. I appreciate everybody joining us. We have two people. We have Bertha Hayden and Danny Kaiserman from Beit Tzedek. We're going to talk to us about conservatorships and elder abuse. And we also have Johanna Tai-Van-Dat, I'm sorry if I didn't pronounce your name correctly, and Linda Vu from the Santa Clara Courts Self-Help Center. We're going to speak on the same topics. And I know I received from Beit Tzedek a PowerPoint presentation. So I'm not sure if that's where we want to start. That's on, I'll leave it actually to the subcommittee if you'd rather start with the discussion of elder abuse or conservatorship.
How long is the PowerPoint?
Well, it's, let me tell you.
I think it's about 7 slides.
Yeah.
I don't know. I feel like if we have guest speakers, we want to let them go first so that if they have other business to take care of, but that's totally up to the group.
Right. We have 4 guest speakers on 2 topics. And so that's why I wanted to find out. Maybe we should start with this since we have this presentation. We can start with the presentation on elder abuse. Let me bring that up. Can everybody see that? Is that showing now?
Yes.
Okay, great.
It's
So
not showing in full slide for you, Linda.
it's not?
Not for me. I see a bunch of different windows.
It's presenters mode. Whoever's showing it just needs to take it out of presenters mode.
Let me just try that again. Oh, I see. Does that look correct now?
You got it.
Okay.
All right, so this is my slide deck. Hi, I'm Danny Kaiserman. So I'll just jump in with a few slides on elder abuse. And I was told we have about 8 minutes, so I'm going to set a timer and hopefully just go through this quickly so we have some time for questions. Next slide, please. Great, so a little bit about my background in elder abuse and Beit Tzedek's background. So in 2017, we started a self-help elder abuse restraining order clinic in downtown LA at Stanley Moss Courthouse. And that's because Beit Tzedek was getting so many calls on elder abuse and people wanting restraining orders. And we were representing folks in those cases, but the quantity got so many that we couldn't represent all of them. So that's why we moved to this self-help model. And I haven't crunched the numbers for 2020 yet, but in 2019, we did meet with 288 litigants through that self-help clinic just at downtown Stanley Moss Courthouse in LA. I will say since the pandemic, we've moved to a remote model, and we are now assisting folks at all the different courthouses in LA County, Van Nuys to Pomona, Long Beach, everywhere. So it's changed a bit, but we're still seeing really high numbers, probably even potentially more than 2019, I would say, based on recent figures. So we do the self-help model, but we also, on a case-by-case basis, through kind of the other hat, the non-clinic work, we do represent petitioners in elder abuse restraining orders, especially more complex ones. And in addition, Bethzetic is expanding its services in elder abuse and conservatorship work to more rural areas, specifically the Antelope Valley in LA County. And I guess, I'm really only speaking of knowledge of what happens in LA. I do know there's some kind of similar clinics in other counties in California, but ours is kind of the most, I guess the largest in terms of numbers for sure, because it's LA County. And also ours is the most consistent. There's some other models in other counties where they work exclusively with pro bono attorneys, but we're kind of the only nonprofit that has this court partnership model. And for counties, and hopefully the other guest speakers can speak to this, that don't have kind of a Bethzetic model in LA, a lot of self-help programs do offer assistance with these types of restraining orders. And also I know, at least in LA County, that our domestic violence clinic, which is run through the State Bar LACBA program, they also provide assistance with elder abuse restraining orders. Next slide, please. So I think there's some unique challenges to working with older adults, and I should say older and dependent adults, as this type of restraining order applies to both older and dependent adults, though it's often shortened to just elder abuse. First of all, these are victims of abuse. So from that alone, that they've experienced trauma, and the restraining order process is unique because it's asking them to relive that trauma and tell you all the details and give you specific examples and what did the abuser say and how did they hit you, where did the abuse occur. So that's a really big challenge for victims to have to relive it through working with an attorney in our case to prepare this restraining order. There's also a lot of crossover with disabilities when it comes to older adults. Hearing impairments, visual impairments, and then the biggest one that I think makes this population really challenging is the issue of cognitive impairments. So declines such as dementia, Alzheimer's, you could have a UTI and experience cognitive impairments, stroke victims. So those kinds of things come up a fair amount. And then the other big thing with older adults is that a lot of times they're accompanied by a third party. So, this may come up with children's law, but besides that, like normally when someone's seeking legal services, it's for themselves. But with older adults, seniors, they often need help with transportation. So by that alone, they're coming with a family member. They may have a power of attorney. They may have a conservator. So there's a lot of who is the client issues coming up, a lot of ethical concerns. Who are you representing? Are you representing the third party or the elder? Do they have authority to speak to the elder? Is the third party an abuser? Those are big concerns that come up with our work. So, there's a lot of best practices in terms of speaking with elders alone and, really hearing their voice and not the person who brought them in necessarily. Next slide, please. So there's different restraining orders. There's civil harassment, domestic violence, elder abuse, and there's different eligibilities for each. There's a lot of crossover between domestic violence and elder abuse restraining orders because so often the abusers are family members, but you know, there's some slight differences in terms of remedies that are available and standing issues, who can petition on behalf of an elder. Big things that come up are differences with move-out requests. Also, you know, there's some new law about coerced debt that has applied to domestic violence, but not elder abuse. So there are these little nuances that you should consider when determining what restraining order is best for the victim. Next slide, please. And then I just want to point out that the definition of elder abuse and all these things are under ADACPA, which I cited if you're curious. A big part of elder abuse that we see come up in definitely a majority of our cases is financial elder abuse. And that has an undue influence definition that gets pretty nuanced. There's a 4-factor test, which I listed here. You know, a lot of times people don't even know it's financial abuse because they're just so used to it, giving their credit card or being intimidated into signing a check, or, you know, those types of things that come up quite often in conjunction with another type of abuse. Next slide, please. And then in the intake for restraining orders, it's fairly common for other legal issues to come up that can't be handled through the restraining order, which has a limited, you know, set of remedies. So you've got real property fraud, financial elder abuse. Remember, with the restraining order, you're not getting money back. It's kind of a preventative action to, you know, stop further bleeding in a lot of cases. You see breach of fiduciary duties, conversion, crossover landlord-tenant issues as well. And elder abuse really, even within restraining orders, there's this intersection with multiple types of laws, because you've got the criminal protective order, which comes into play sometimes, family law, civil law, probate law. For example, if the victim of elder abuse is conserved, then it would be heard, the restraining order would be heard by a probate judge instead of a family law judge. And some counties have it heard by civil law judges. So there's a lot of differences that come up there. And I have a restraining order case right now I'll share where, I mean, basically this whole list of issues all came out because they wanted a restraining order. And then you start asking more questions, and there's trustee abuse and fraud in the trust documents and conversion. And she lived with the victim. So, I mean, basically every single one of these came up just in the intake for a restraining order. Next slide, please. That might be it. Okay, I tried to keep that short, so I will let my colleague Berta present, or I'm not sure if one of the court staff is going to talk about elder abuse specifically. Thank you.
What does the subcommittee want? Would you like us to go as an agency, or would it be more helpful to hear both, hear the presentations by topic?
I personally think, I'm not on the subcommittee, but I think it would be helpful to hear it by topic, personally. If that's okay, group?
I would agree with that.
All right. So Fariba, who would that be from the court?
No, I wasn't expecting to present on elder abuse. I was only asked to bring my subject matter experts on conservatorships, but we do handle elder abuse as well. And so thank you for the presentation. I don't know if this is a question answer session.
I think so. I think, Linda, did you think there were 2 presenters on elder abuse? Linda?
Sorry, it just took me a minute to unmute. I didn't know if there was a second presenter on elder abuse. I just knew that there were 4 presenters in total on these 2 topics.
Okay. So I think questions sounds good, Fariba.
Okay, so thank you again. Very helpful. We here at the Self-Help Center in Santa Clara County do help with all kinds of violence prevention issues and formed on both sides because we're a court, we're neutral, got to help on both sides. But so in terms of your position on whether you have a position on whether this new group of paraprofessionals, licensed paraprofessionals, should be allowed to handle elder abuse? You have a position? You don't have to, I'm just asking.
Yeah, I mean, I guess I definitely have some concerns. I think that, you know, because of the nuances, especially with the capacity and ethical issues about who the client is that come up in, you know, the vast majority of these elder abuse cases, I'm just not sure, especially without attorney supervision, that, you know, there wouldn't be misjudgments made and that could ultimately harm the victim. So I have concerns, but you know, I defer to you guys, of course, as the folks examining these issues.
So let me just take that one step further. You talked about attorney supervision, and I think I sound like a broken record sometimes, but I just kind of compare, and you know, right now an attorney with a license to practice law can do whatever, right? They're of course responsible for following rules of professional conduct and malpractice and all that, but basically they don't have to check with an attorney if they don't want to. So they can take elder abuse, and they've never done elder abuse before, go on the Judicial Council website, check a couple of boxes. So in terms of not requiring attorneys to check in with another attorney to, if they've never done something, and then this new group of professionals where if we have a really great training program and licensing program, continuing education program and all that, what is your other reason for wanting them to get supervised by an attorney? If you can answer that question.
Yeah, I mean, I guess I see a lot of mistakes made because people often come to me after trying to do it themselves, or, you know, going to a document prep service or something like that. And oftentimes they're, you know, being given even the wrong forms for restraining orders. So it's a whole mess. You have to get, you know, a certain type dismissed and start all over, which could create a gap in protection, which is definitely not desirable. And even there's just such different remedies. So like even at that first intake level, you know, I do think the guidelines that attorneys have in terms of ethical responsibilities kind of gives them a leg up. I mean, I'm not sure what the training would consist of, but I guess, yeah, it's just also because so many other issues come up even at the intake. I don't know, I guess I can't speak to whether a very well-trained paraprofessional could spot those legal issues, but I'm definitely concerned because I think folks just doing the restraining order, it's not ever just the restraining order. So many other things come up.
And I see that Joanna is shaking her head. I don't want to put you on the spot, but we see these mistakes as well. Did you want to comment, Joanna?
Oh, I think, yes, just as you mentioned, Danny, a lot of crossover issues, and I think it's really important. I mean, at our court, we have our court specialists who are really trained to be able to issue spot and triage, but when there are complicated issues that come up, they'll always have an attorney to run things by to make sure, like you said, that the right forms are given, because it's, I mean, these people are coming already with a very difficult situation, right, that they're handling. So the worst thing would be for them to fill out all the wrong forms, right, because they're pretty form intensive, both for restraining orders or conservatorships. It's really form intensive. So you would want whoever talked to them to really be able to parse out the different legal issues and the overlaps and those kinds of things.
Okay, thanks.
And I guess I would wonder with the paraprofessional group, whether the same kind of ethical issues, you know, in terms of confidentiality and third party, just because that comes up in nearly every elder abuse case, whether they would be, you know, have to abide by those same standards and rules of ethics.
Yeah, we're currently working on those in another committee.
Danny, this is Sharon. Can you speak to your income qualifications to see these cases? My understanding is that you can see more people because they're over a certain age. Is that correct?
Yeah, so we can actually see anyone at our clinic regardless of income, because as long as they want a restraining order with our court partnership grant, then that's where the funding comes from, that they want the restraining order. And I didn't mention this, but actually because we are a self-help clinic, we do help both sides. So we do help respondents as well through our clinic. Now, if we're gonna refer someone to BetCedic for representation, BetCedic does have its own income guidelines, but if you qualify as a victim of abuse, then we could probably represent you. But, we have some, I guess, internal eligibility standards based on, if you're a millionaire and you can hire a private attorney, even if you're a victim of abuse, we're probably not going to take that case.
And is your self-help center able to see the majority of folks that come and need those services?
Yeah, I do think we're meeting the need. I mean, there's a lot of need, and I think there's even more need for representation for a lot of the same reasons I talked about with the vulnerability of this population and, capacity issues or other impairments. We're just helping with the paperwork, which is huge. It's a significant amount of paperwork, but I do think there is definitely a gap in services when it comes to the hearing representation, because, we're only taking a small slice of that through BetCedic, but the majority of cases are unrepresented.
I had a few questions. Within your program, would there be an opportunity for paraprofessionals who need to get a certain number of experiential hours? Would you be able to take on interns or paraprofessionals that are trying to meet those experiential requirements?
I would defer to my colleague Berta for that one.
Okay, so Berta, you got a preview of the question coming to you.
Oh,
Are you seeing?
I think we can answer it now if you'd like.
Okay.
Our agency always values volunteers and actually often hosts paralegals as they're trying to complete their certificate hours, law clerks, bridge fellows. So we also hosted the incubator program that the bar had. So we have a department, a pro bono department that is responsible for that. But I think that if paraprofessionals were something that were there, we'd probably treat it similar to having paralegal and law.
Nothing's been adopted yet, but we're looking at requiring 1,000 experiential hours for any paraprofessional. And to qualify for the family law training, not only are they going to have trauma-informed education at the beginning, as well as part of their CLE, domestic abuse training to deal with that, specifically in family law, and probably requiring a significant percentage of those experiential hours to be in a clinic, whether it's a domestic violence clinic, an adult abuse clinic, or restraining order clinic. So that's good to know. Do you feel that there's an unmet need? In other words, are there part of the population in your geographic area that could use your services, but you do not have the capacity to assist them currently?
Yeah, I definitely think there is an unmet need. A lot of it's not so much that we don't turn people away, but a lot of people don't know about us. And, we're working to get the word out with every single courthouse. And we have seen through the pandemic an increase in referrals, but if everyone knew about us, we wouldn't be able, as we're currently operating, to handle that capacity. But I think we are currently, because we're not getting as many referrals as I know could use us. And I know that because tons of people come kind of as Johanna mentioned, after the fact, after they were given the wrong stuff, et cetera.
Okay, and then the people that are specifically delivering services at VetSetic in this area, I assume it's not just attorneys only, correct?
Yeah, so we do rely on volunteers with attorney supervision to do certain parts of the restraining order, like draft declarations, which we do with every restraining order. We still always have an attorney review the case before even starting on the paperwork because of those complexities with intake issues. And honestly, I would say right now it's all attorneys doing restraining orders because of the pandemic. But even before, we were doing almost all of the intakes just because that's such a critical part. But we do use law students and other attorney volunteers to help with declarations.
And does that include paralegals then too?
I don't think our clinic has used paralegals, maybe one in the past, but just because it hasn't come up, we would certainly welcome them to assist with the declarations.
And then in terms of, it sounds like you have one of the better developed programs. So for example, I don't know what we have here available in San Luis Obispo County, but in terms of if we were looking at the state as a whole, there's a lot of geographic areas that don't have entities such as VetSetic providing these services. Is that something?
That's my understanding. I'm only aware of a couple other similar programs, and they're not as scaled up as ours. And one concern is I'm not sure that all self-help services do these types of restraining orders, because actually in LA, the self-help courts were not helping with elder abuse restraining orders. The domestic violence clinic was. So I think it's a kind of a county by county thing, but definitely VetSetic is the biggest program that I'm aware of. Okay,
thank you.
Thank you.
We have senior adults legal assistance, but unfortunately their funding is very limited. So I don't know if Johanna and Linda remember, but whenever we want to refer a case, we're not really sure if they are able to take it or not. So we do elder abuse at our office and try to get them attorney representation through SALA.
Any other questions? All right. I think it sounded like Bertha. Maybe you were next.
Thank you. Very helpful.
Thank you.
Bertha, you're on mute.
Got my Zoom skills down. I apologize. Thank you, Danny. My name is Bertha Sanchez Hayden. I'm the directing attorney at VetSetic Legal Services for the Caregiver Unit. I've been with VetSetic since 2006, and I have done work in probate as a paralegal, as a certified law student, and as an attorney. I've worked both in direct representation and in a self-help context. So I'm happy to also answer questions from like those different perspectives. Our clinic was started in 2007, and the first year, our clinic assisted around 450 individuals. In 2019, we recorded assisting 1,412 individuals and coming into contact with over 2,000 individuals that had questions regarding conservatorship. At one point, we don't have the most recent data, our program was responsible for 70% of the conservatorship filings in Los Angeles County. Our clinic operates as a free service to individuals seeking to file probate conservatorships, whether that's a general conservatorship or a limited conservatorship. We do not assist individuals who are trying to file a conservatorship over an estate that does not meet the small estate requirements through the probate code. Meaning, if somebody wants to obtain power over somebody's estate who is in excess of $15,000 in assets and has more than $2,000 in income a month, excluding public benefits, our clinic is unable to assist. And mostly that has a lot to do with the additional requirements and the mutations of the conservatorship if it gets granted, in terms of inventory and appraisals, future accountings. I think one key thing to remember about a conservatorship is that once it's established, it is not a final transaction, right? It comes into existence, and it's under the court's jurisdiction until whether the court terminates it or whether the conservatee dies or it's no longer necessary. Stepping back a little bit and just looking at our conservatorship system in California, we have 3 types of conservatorship. And I apologize if this is a little bit too the elementary, and if you don't want me to go into it, you can just say, talk about your clinic. Okay. So in California, the 3 different types of conservatorship we have are the LPS conservatorship that's used to assist individuals who are dealing with a mental health issue, a drug dependency. Those types of conservatorships are governed by our Welfare and Institutions Code and are heard by our mental health court. And we also have our probate conservatorships, what we routinely call a general conservatorship, most commonly associated with individuals who are suffering a neurocognitive impairment or a traumatic event. And we also have our limited conservatorship scheme that is designed to support an individual who is severely impacted by a developmental disability that originated before the age of 18. These, although our clinic can only assist probate conservatorships, but I will say, and the reason is because an individual does not have standing to file an LPS conservatorship, right? In order for an LPS conservatorship to be initiated, the Office of the Public Guardian has to receive a referral from a approved mental health facility, and then the public guardian has to decide whether they will initiate that process. And a public guardian at one point can invite a family member to serve as a conservator, but it's extremely frustrating for individuals when they can't take the first act to protect their loved one. Mental health conservatorships only last a year and can be renewed as necessary. One of the 2 key powers that individuals can obtain under an LPS conservatorship is the right to place somebody under a locked facility for treatment and to force psychotropic drugs. Those are, and for somebody who's dealing with a mental health crisis and wanting to keep somebody in safety, those are 2 key powers that they may need. In our conservatorship clinic, we tend to see a lot of people coming in and wanting to find answers regarding LPS conservatorships because they're just frustrated that they can't be the ones to start the process and to protect their loved one. And there is crossover. You can have an LPS conservatorship and a limited conservatorship. So sometimes people, or a general conservatorship, sometimes an individual might be what we in our community would call dual diagnosed. I know in different professional communities that term is used differently, but in our community we say dual diagnosed to have a mental health disability and either a neurocognitive impairment or an intellectual and developmental disability. In our clinic, the ones we do help individuals file for a probate conservatorship of the person and small estate, general, or a limited conservatorship of the person and small estate. We use document preparation software created and continuous improved by the Judicial Council Law Help. And we've also recently have started supporting litigants through accessing Guide and File, which is a product of the court. And I know Santa Clara, it's great to be on the phone with Santa Clara County because it's my understanding that there are also the county that avails themselves of that great resource. Our clinic prepares documents for individuals and then navigates them through the technical process of obtaining the conservatorship. One thing about conservatorships is that once you file, it triggers the involvement of other professionals, right? So in Los Angeles County, the court will appoint a court-appointed counsel, a CAC, to the proposed conservatee. It is my understanding in other counties, the private bar is not used, but instead maybe a division of the public defender's office is used. I'm unaware how it's done in other counties, but here it is a court-appointed counsel, so there will be an attorney involved in every matter. And that court-appointed counsel has to, I think similar, sir, to what you were mentioning, undergo specific training to take on certain type of cases. So the general conservatorship, to get on the panel, you need to have certain experience in probate law. And then, and you can look at our local rules if you're interested in kind of seeing what the training are for those public counsel compared to what you might be thinking for your own paraprofessional program. And they, for a limited conservatorship, you actually have to do additional training outside of the core training to represent somebody in a general conservatorship. I would caution anybody from thinking, because the work that we do is very form intensive, that it's transactional, right? I mean, in conservatorships and in elder abuse, we're dealing with vulnerable people, sometimes in a crisis. I think the difference between a limited conservatorship and a general conservatorship is that more often than not, in a limited conservatorship, a family might be able to plan for the event of needing a limited conservatorship, as opposed to a general conservatorship when somebody might have gotten into a car accident, had a stroke, or the onset of dementia without doing proper planning documents, you know? So it's a very different, you know, situational aspect of when you're starting it. Emergencies, however, do occur with limited conservatorships as well, in terms of them being established when somebody turns 18. Typically, I've seen them in order to obtain medical treatment or access to regional center service or educational services. So backtracking a little bit, I mentioned that filing a conservatorship triggers the involvement of a court-appointed attorney for the conservatee. It also triggers the involvement of a probate conservator. That probate conservator goes out to the home of, or was going out to the home, I'm not quite sure if they're doing all, they're doing phone visits or personal visits right now. And they go into the home and they do an extensive check as to the suitability of where the adult who is vulnerable is living. They will open closets, they will open refrigerators, they really look to see that the individual who is, you know, who rights might be stripped away is living in a suitable and safe environment. Then if you're filing for a probate conservatorship, it also triggers the involvement of the regional center. The regional center is supposed to receive notice of a limited conservatorship proceeding, and as well as provide a report in terms of their recommendations as to which powers, which I'll get to in a minute, they will recommend. Some of the mutations that happen with that is not everybody being part of a regional center is voluntary. Regional centers are nonprofits that we have in California that are funded by the Department of Developmental Services, and to be crass, are supposed to give services from cradle to grave. That's their motto, to individuals who are impacted by, to residents who are impacted in California by a developmental disability. Some people, depending on the generation that we serve, we see some people that find a social stigma with being associated with regional center. A lot of the older parents that we serve feel that they wouldn't be doing their job if they access those public benefits. And so you'll see somebody that, a sibling coming in to obtain a conservatorship over their sibling who might be 45, who was never part of a regional center. And then you're looking at, you know, a possible mutation that I'll get into there is when you file, and there was some legislation around this, is there is a probate code that says that it's up to the, it could, you know, if the impact is so severe that it substantially impairs in a majority of the areas, it's within the judge's discretion to be able to establish a general conservatorship. I would say that in my experience, most judges are hesitant to establish a general conservatorship when there is a developmental or intellectual disability. And there was proposed legislation to require to do away with that discretion and require a limited conservatorship when there's an intellectual or developmental disability that the person is diagnosed with. But then you're dealing with, one of the mutations happens there is, you know, getting the conservatorship obtained in the absence of a regional center, advocate, trying to get the person to be eligible for the regional center and going back and doing that almost like social service in order to get them the conservatorship processed. So that's who gets involved. Spending a little bit more time on the mutations of conservatorships. For both a general conservatorship and a limited conservatorship, an individual can ask for the care, custody, and control of the individual. Beyond that, if you want medical powers in both, you have to file a capacity declaration completed by a physician, a neurologist, or a prayer healer. And then if you're filing for a limited conservatorship, you have to specifically ask for the powers. They're called this under section 23.5B, if I'm recalling correctly, that you want to be able to assist the individual, commonly refer them as the 7 powers. So a conservator can ask for the right to be able to contract for an individual, to make educational choices, to make choices regarding their residence, to make choices regarding their social and sexual contacts, to make choices regarding their entrance into a marriage or domestic partnership, to decide where they're going to live. In Los Angeles, there are some regional centers in terms of the recommendations that they make that will never recommend certain powers because they feel that it's the right to marry or enter into a domestic partnership or control your social and sexual contacts are a fundamental right that the court should not interfere with. Once an individual, I do see, even when I'm representing individuals, that the word limited for the public tends to be something that they feel like they're getting a lesser form of conservatorship. So I think, you know, and people will try to file for a general conservatorship. And we spent a lot of time in our program trying to educate people on how it is not better. One is not better than the other. They're just different to be able to meet the different needs that an individual who's, you know, 60 and had early onset dementia has a very different life pattern or built up different life experience than somebody who perhaps at the age of 18, their developmental disability is so severe that they won't be able to participate in a traditional milestones or traditional employment history. There is, again, crossover, I think, between the two in terms of dementia powers. In a general conservatorship, with the supporting documents of the capacity declaration, you can ask for the ability to place somebody in a secure facility. That's not like the lock facility under the LPS, but more for the safe and for somebody who might have wandering tendencies. And you can also ask for the ability to administer dementia medication. We're seeing a large population of individuals who are diagnosed with Down syndrome also get diagnosed with early onset dementia. So you're seeing a situation where somebody could, you know, and actually I should say, a lot of times with with individuals who are impacted by Down syndrome, that's somebody who may be able to engage in a decision-making process and sufficiently to be able to execute a power of attorney and a power of attorney for healthcare. So it might not be until later on where a family member might need the intervention of those dementia powers. So in that case, you're looking at that sophisticated analysis of the case to know enough that you would want to file a limited conservatorship and you can ask for those dementia powers. Other issues that might come up are with...
I'm sorry, I'm just gonna interrupt a little bit because we've got a couple other speakers and I know I wanna give time for the subcommittee to talk as well. So if there's something that you really haven't gotten to, but I think if we're in the examples phase, maybe we can move on to the other speakers and then maybe hit some of your examples during the questions and answers.
Sure.
Okay,
sure.
Great. So then we have 2 folks from the court. I'm not sure who's gonna go first and how you wanna proceed.
Hi, I'm Joanna, and from Santa Clara Superior Court Self-Help Center. And so Fariba asked Linda and I to join you today. So Bertha, thank you so much for that overview. Now I don't have so much to cover. That was really great. I really appreciate it. So with our Self-Help Center, the way we've worked with litigants with conservatorships. So for general conservatorships, they would come into the office. So this was pre-pandemic, and we would go over the forms with them with sample packets and go through the process with them and explain to them, the differences. And yes, a lot of people have questions when it comes to conservatorships because they do think the limited conservatorship is a lesser conservatorship, or somehow they're not getting as much out of it. And so we try to explain to them that they're different, that limited conservatorship, you have certain powers versus in a general conservatorship, the court is going to say which powers you're limited by, but it's broader. And it depends on the needs of the conservatee or proposed conservatee. So with the general conservatorships, like I said, it was one-on-one. They would come into the office and we'd go over the forms with them. And now since COVID, as like all of us know, everything's changed, and a lot of it is they're going to access our services through remote assistance. So they'll email us, they can access the forms online. We've made our website a lot easier to navigate with like big tabs that say complete forms at home through Guide and File. We also had the help previously to Guide and File through Law Interactive, the hot docs, to prepare documents for people. And so with the limited conservatorship, we had always had this workshop model. So in the past, we had partnered with an agency, Parents Helping Parents. They provided the space, and then they would triage their clients, right? And the ones that needed limited conservatorships would be signed up for our workshop. We would go over the forms with them and help them complete the forms. And as the program evolved, when we moved into our new building, we had the space and the capacity to hold the workshops in-house, so at the courthouse. And we would have them prepare an intake that we created that basically answered all the questions we needed to populate the forms. And so we would populate the forms for the customers and then have them come into the office the day of the workshop. They would sign up ahead of time, and then we would go over the forms with them and instructions. And what was really, I think, neat about this population is, yes, like the people come to us in crisis for the most part, and so they're emergency, same day kind of things. But for limited conservatorships, as Bertha mentioned, some of the families are able to plan ahead of time for this, and so they're more prepared and have the information, to work on ahead of time, especially the list of all the relatives that you need to serve or at least give notice to, right? Which is really unusual for people because they'll say, well, the grandparents live in another country, or they don't speak English, or, something like that. So we would explain the process, explain what service looks like, explain what mail needs, how the parties, for instance, grandparents are living in the same household, they still need to be personally served, right? Or served individually by mail. And to make sure that we would provide the regional center with enough notice so we could do the report in time for the court hearing. So a lot of it was guiding people not through just the process of the forms, but what it's going to look like the day of court, what to expect in the weeks following the time that they're filing the paperwork. So it was more services that way to really guide people through the process. And for the most part, a lot of these families that we would be interacting with for the limited conservatorship workshop would not come to our services in other methods. So with the self-help assistance that we have, a lot of family law, other civil issues, but for limited conservatorship, we found that these families would not otherwise interact with the courts at all. So it was just a really great opportunity to access another group of people that wanted access to the course and didn't have the means to pay another money to their forms or something like that. So they're like super grateful and just really, a benefit, right, for their children usually who now need, again, like medical consent for things or for schooling or anything like that. So I can have like Linda jump in and talk about more of the specifics. But just to give you an idea, in terms of Self-Help Center, for 2019, we helped over 42,000 people coming through our office. And then in this year alone, in terms of the families with limited conservatorship, we've served so far 188 families.
Oh, hi, I'm Linda. Sorry. I might hear some. And I'm one of the staff attorneys at the Self-Help Center. So since COVID has come into place, we've taken our workshop along with my colleague Neil, who's not here, and we've gone virtually. So the way what we've done now is people sign up online through our court website. We take them, we place them on a wait list. We assist anywhere from 12 to 16 families per workshop that's held once a month. And we actually use a guide and file. We kind of switched from a Law Help Interactive to guide and file. We'll send them the link. We'll have the litigants type up their own forms. When they're done, they email it back to staff. Neil and myself will go through, we'll review it, we'll put it in a packet, tab it, we'll print it out, we'll physically mail it to them. About a week before the workshop, we then send out the Teams link. And on the day of the workshop, they meet with us virtually like we are right now. We're able to go through the forms with them, do what we did as if we were in person, and then take questions at the end. So that's basically how we've been serving families since, I can't remember, earlier this summer, maybe sometime in June, Joanna or Fariba,
Yeah.
right? And so that's how we've been assisting the families. And so far, I haven't heard any negative feedback, so it seems to be working. I think the great thing about Odyssey Guide and File, or even Law Help Interactive, is I've worked with Diana Glick at Judicial Council, and I know Neil, my counterpart, has worked on Guide and File, is we can get the forms to be very Santa Clara County specific. And so it eliminates people going online through Judicial Council, pulling all the different forms, missing a box here, not having the proper address here, maybe not having the powers. It's everything that you would need to come through our workshop. With that being said, Neil and I also get on Guide and File, people accidentally press file, right? So they file it and then they sign up for our workshop, and we end up having to amend anyways because something wasn't filled properly. So the form programs are fantastic, but I still think there's always this need for a human element to kind of take a look at the forms, to make sure it's all correct, ready to go, to help answer questions, to help explain service. Traditionally, before COVID, we used to have an intern or a justice course student, normally the fellow, that would assist us in reviewing the forms and preparing. And they would always check in with myself or maybe Neil if they had questions. So there's, the way our office works is there's always an attorney to help supervise. Joanna, feel free to jump in. And yes, that's basically how we're helping with limited conservatorship workshops now.
Thank you both. Are there any specific questions for my people on how we run our workshop and supervise staff?
Or perhaps general questions on conservatorships for all three.
Fariba, you guys really wouldn't be set up to be taking on part-time or short-term interns for purposes of getting the experiential hours satisfied, correct?
Because of the pandemic, we've had to shut down most all of our internship programs. We currently have one intern and we used to have 13. So we have to just qualify that, you know, once the vaccine is out there. And, you know, today, just a few minutes ago, our court issued a new order limiting access to our court. So we're going back.
Right, everybody's going purple. So
yeah,
let's talk June or September 2021, right? Or we can go January 1st, 2022, based on when our report is due. At that point in time, would you guys be able to make use of the paraprofessionals trying to get their experiential hours met?
Without committing my court to anything,
No,
you know,
not a binding promise.
I have to say that we would treat it the same way as law student interns because we are a teaching court. I consider us a teaching self-help center. And we've always had a group of law students, justice corps members, and I don't see why we couldn't have a new group of professionals in training to help them do good work out in the community when they're licensed. So I'm all for it. And I think Joanna and Linda are shaking their heads. Shake your head if you're not.
Yeah. So I brought that issue up both for you and for Bet Sedek, because I'm thinking a lot of the concerns that have been expressed about paraprofessionals doing these practicing in these areas is based on what all of you have observed as being the worst case scenario, the problems that have arisen when someone didn't have help from one of your groups. And my thought is the best way to get people to issue spot and find these potential problems before they happen is to have them working with the family law facilitator in Santa Clara or BetSedic in Los Angeles or some of these other groups. So, okay, thank you.
But I think I also would add, to that, like what is the need that the paraprofessional is trying to meet, right? Because if you're looking at a training of, clinical program, so, form production, obviously clinic programs are great training. But if you're looking to extend the paraprofessional into more of what a certified law student does, then you need programs where they can get that in court, that court experience, and whether they would be dealing with contested matters.
Okay, thank you.
Can I ask a question? I just want to make sure I'm clear on who gets government funded representation in these 3 different types of conservatorship matters. And if you all are aware, if that appointed counsel or the appointment of the public defender is pursuant to like a state statute, meaning it is consistent across all 58 counties, or it's dependent on the practice of a particular county. Because I'm not clear, and yeah, I'm just not clear. So are you aware?
Yeah, the probate code dictates that the proposed conservatee will have counsel. They obviously have the ability, if they wanted to retain in a probate conservatorship. I won't speak about LPS conservatorships because I don't think that you're looking to, that's a very different system. But if, for instance, if Danny filed a conservatorship over me, the court would automatically appoint someone to me. But one of the questions that the court appointed attorney would have to ask me is if I wanted to retain my own attorney. So I could choose to say no to the court appointed attorney and hire my own attorney. Now, also if Danny filed a conservatorship over me and it was in Los Angeles County, and if it was a non-fee waiver case, my estate would be responsible for paying that attorney in Los Angeles County. So there would be fees. And also, let's say if Danny hired a private attorney, because I think what does get complicated is with estate issues, then Danny would be able to ask the court to also reimburse the cost of her attorney. And also a conservator, if somebody's appointed, can ask the court to reimburse their cost of the expenditures that they take in becoming the conservator. I would say that, the court has adopted, and I don't know if the Santa Clara County, speak to it, but I think one thing that's unique about conservatorships is that you're allowed to base the fee waiver on the person who needs help. So if I want to apply for fee waiver and I'm not income eligible, but I'm trying to help my sister who's on SSI, then I will qualify for a fee waiver. And so I think that there has been a priority to try to keep the cost around conservatorships, just like there's no filing fee for elder abuse, in order to not create any chilling effect of money somebody having to make an economic decision in order to be able to care or be an advocate for someone.
Okay.
I had a question for Linda Vu, or if anyone else wants to answer it. So you talked about the guidance file, and so you're talking about helping people during the pandemic to get access to legal services. Can you guys talk about what happens to those that don't have computer access or who have language barriers? Or people who have immediate needs and can't wait for all of the workshop and going through all the different stages. Thank you.
Yes, of course. So if they don't have access to technology, that's not a problem. I recently had a customer who tried to use Guide and File, and she spent hours, like 3 days worth, trying to do the forms. And she basically told us, I can't do it. So I took her information, I prepped the forms myself, and I mailed it out to her. If people normally don't have access to technology, like with anything else, there's always mail. If not, there's no mail. We'll work some way out to help them on a case-by-case basis. If there's language involved, let's say if the person is Vietnamese speaking or Spanish speaking, for the workshop, we make sure to tell them to have, and it's written in our email, that if you don't speak English, make sure you have a family or friend there that can help interpret as well. So we try to help accommodate people to not allow language or not have access to technology as a barrier to getting our office to help them.
Thank you. And I guess
And
the
our
final question. Sorry, and the final question was, how about those people who have like an immediate rush for like, but they can't go through the different stages of the workshop?
Right. So if that happens, we refer them over to our probate staff attorney, Jonathan Kahn. So we give him the number, he calls over there, and then he helps them.
Thank you.
Yeah, John doesn't work for the self-help center. He works for the
Right.
court.
Hi, this is Brady Dewar. I'm in the Office of General Counsel at the bar. And I just wanted to follow up on Leah's question about the availability of government assistance. My understanding is that probate codes 1470 to 1472 talk about situations where the county will be ordered to pay. But I'm wondering if there are sort of cracks in that system, either middle income people who aren't income qualified, or certain types of litigants who just aren't covered by that statute, where there's still a need.
So I think we're looking at it from two different perspectives. So there's the proposed conservatee and their access, right? In terms of like, so if you're looking to determine if paraprofessionals might be eligible for applying for court-appointed panels, right? And having that experience. But conservatorship is an adversarial process. So the attorney that the court appoints is for the purposes of the court appointed, the proposed conservatee. And for instance, somebody who is receiving clinic service is in pro per, and so the county is not paying for. When you say government funded, other than like, the state bar funding our equal access program, our clinic program, the PROPER is receiving that type of assistance. BetCivic also, before we were doing clinic program, we also do direct representation for income eligible individuals. So that's the type of direct representation that in the work we do, somebody might get, the petitioner, the proposed conservator might have counsel.
Gotcha. So it's mostly the conservatee who is getting the county funding.
It is, yes, in Los Angeles County is always the proposed conservatee who has that attorney. And thank you for making that distinction. So like, for instance, in Los Angeles County, if I'm the proposed conservatee, Danny files a conservatorship over me, the court will appoint me an attorney. I do not pay that attorney. The court will order the County of Los Angeles to pay for those fees under PACE. If I did have an estate and Danny filed for conservatorship, let's say I have a rental property, Danny could ask the court to reimburse her from my, from my estate to cover her cost of obtaining a private counsel.
Okay.
And so in terms of like, if you're looking, well, what's the unmet need for the petitioner, right? Because not the proposed conservatee, because that need is being met by, the local practice of giving the proposed conservatee counsel. Somebody who might not be eligible for a legal aid system, might not be able to handle their matter in pro per, might want to talk to a private attorney about having their costs reimbursed from the individual's estate, like a contingency matter, essentially.
But if there wasn't an estate, then that person would have a need. The petitioner, if the conservatee doesn't have an estate, the petitioner, if they can't afford counsel, has an unmet need. Is that what I'm hearing?
That petitioner would have an unmet need, I think, for a matter that would be unable to be met by the clinic service. So yeah.
Gotcha. Thank you.
Are there any other questions? If not, we have about 25 minutes left, I think, of this meeting.
I've got a question for Berta, which is, what is your opinion about paraprofessionals doing this type of work?
You know, it's really hard for me to form an opinion right now because I think that so much is dictated by the skill training and the license and the education and the provisions, and also to know the scope of the work, right? I mean, I'm obviously somebody who's, I feel I was enriched and my clients are enriched because I was a paralegal, I was a certified law student. And so I think that it's important to have those programs. But in terms of this program that would seek to mirror what an attorney would do, but I mean, I don't want to mischaracterize the program, but my understanding is to create professionals that it might be more accessible from an economic point of view to an individual. So I think a lot of that would be like, well, number one, what is the need and what is the importance of building up our self-help programs to have these free services for individuals who are already vulnerable. You know, what are the levels of complexity where I know somebody said, well, not all attorneys know how to do certain things. That is true, but they do have an ethical responsibility not to take those matters. I think elder law itself is when I started doing this work, people didn't know what conservatorship was. And now I see like people think conservatorships are superior to powers of attorney. So they're not even exploring the alternatives which are required by the court. I think this area of law is growing. And so I think, the effectiveness of a program very much dictates on the strong educational and scope limits that this group will put together.
Anything else, Sharon?
No, that's it. Thank you.
Okay. Thank you all so much. And you can feel free, I think, to stick around on the screen or not, totally up to you.
Thank you for your time.
Thanks.
Thank you.
Linda, are we next going to the updated list of topics and subtopics reflecting Fariba and Stephen's work?
We can either go to the whole thing or we can just look at, I prepared a slide that just calls out the remaining outstanding topics. Are you able to see that now?
Yeah, it is in presenter mode.
Hold on, sorry about that. Hang on. Let me try again.
And just FYI, I'm here. I'm just eating my lunch. I didn't want to subject all of you to that.
Oh, hold on a second. Sorry. Too many things that I'm trying to manage here. Can you see this now?
Yes.
So I posted to the agenda the full updated list of the recommendations that were fleshed out in more detail by Stephen and Fariba. And these are the topics that are at this point were to be determined. So we can either just discuss these or I can bring up the entire list if the subcommittee wants to review the entire document.
I'll defer to Fariba whether she wants us to go over the things that we jointly recommended. These kind of represent things that we're still hanging with the two of us that we hadn't reached a final conclusion on. So I'll leave it to Fariba. Do we want to talk about what we're not sure about yet or what the things that we were pretty solid in terms of what we would recommend?
I wanted I wonder if subcommittee members have had a chance to review the list. Since me and you have already discussed what we agree with, we have a joint position. I thought maybe we can take questions on those. And if the committee agrees with our position, great. If not, we can have a discussion and then move on to topics that we did not reach agreement. There's some things that we left out too, as I mentioned yesterday. How's that sound?
Is what we're seeing what you did not land on?
What?
I'm checking right now to compare. I think.
Yeah, I was.
Yeah. Okay, so the disputed venue issue, yes, we were still talking through on that one, whether there was any kind of specific knowledge or training that an attorney would bring to the situation that would not.
And it was more like we didn't have time to get through them.
Yeah.
Rather than we disagreed.
Yeah, we went through. If you looked at the list that we did, it was pretty extensive.
Mm-hmm.
And there was like 3 or 4 areas. So let me have violence prevention.
Actually, this one I think we agreed.
Yeah. Can I share my screen for a second? Because I can actually show you the working document that the slide was made from. Is that okay?
Yeah.
Okay, share. So here's the working document that me and Fariba started with, where we reached agreement on what should be included in terms of dissolution. We broke it down. Basically what we did is we started with a form petition and went through each of the different areas that are identified in a form petition. Then we added in the things that would be on a petition for paternity action. One of the things that we excluded was annulment based on these 5 areas. And it was because we felt this was where this involves crossover issues. This involves psychological issues. Because of making an allegation about any of these things could lead to criminal prosecution, we felt pretty confident that this should be excluded. But otherwise, annulments that were more straightforward, for example, based on bigamy or the age of the party, we didn't see an issue with paraprofessionals addressing those. This paternity, the one area of paternity we excluded, this is a newer and more difficult area with regards to more than 2 parent cases. That's a fairly new statute. Not a lot of attorneys I've litigated that issue, but it's not been litigated by a lot. And it also has to do when you've got competing presumptions. So this was an area that we excluded under paternity. Everything else would be okay. Where we were at on that, we were not opposed to and did not disagree with including our violence prevention category, which included the family law version, the elder abuse, gun violence, workplace, civil harassment. I think what we had said though is there were certain things we wanted to make sure. And at first we were thinking maybe this should be a sub-endorsement. But after we had a licensing meeting yesterday, and Julia Brenelson brought up a really good point. Why shouldn't everybody that's going to be a paraprofessional get the training that we want for domestic abuse issues? And at the heart of it, one of the really, I think, good points that she brought up was you've got to be able to screen. Like, in other words, a paraprofessional attorney, paralegal, LDA, whoever, should be doing a screening at that initial intake, because there are so many victims of abuse that do not recognize that they've been in abusive relationships. I spend probably 10 minutes of every consultation in any case, regardless of gender, going through what constitutes disturbing the peace. Now I'm also including discussion about coercive control. So our feeling was we should include within the family law training on domestic abuse and these other areas, and include the experiential clinic hours that we talked about or mentioned earlier, as well as having ongoing CLE in this. And I think the one thing that we were not sure about, let me go to my footnote 3, had to deal with having an attorney, whether we should require an attorney to review this. I think if we make this a mandatory component of the family law education, I would be less concerned about the attorney review if they're getting the education, the experiential. Freeba, do you have a?
I think that's trauma-informed training, which trauma-informed training, trauma-responsive training, and trauma resilience training, all those should be included in curriculum for attorneys and paraprofessionals, in my opinion. We do that at our court. Every other year, we present the training to anyone who volunteers for the court. Our court staff and judicial officers attend to. So I'm definitely in agreement with that. I think that's absolutely required training for issue spotting. And then what do you do when you actually spot the issue? Okay. And how to talk to someone who's a victim of domestic violence, and really how to talk to an abuser, you know, because you could be dealing with both sides, right?
Correct. And making them recognize what they've done. I don't get a lot of clients in this area, but where parents have not realized that their behavior of, you know, speaking ill of the other parent, the discount, I guess there's a dispute about alienation, but speaking ill of the other parent is telling a child that they're half bad and making people aware of some of their bad conduct that they didn't recognize. I think fits in with that, Freeba.
And really the issue of whether the child in a relationship with their children are really your second client. You know, who you don't represent them, but everything is best interest of the child, reality check. Anyway, there's a whole lot to discuss. With regards to the requirement of having an attorney review your work, you know, I reached out to the domestic violence agencies in my county, the larger ones. I've heard back from one of them so far, one of the larger ones, that they don't regularly have because they don't hire attorneys. In the olden days when there was money, our larger agencies had an attorney on staff, but now they just have legal department staffed by basically paralegals, and they reach out to, they have relationships set up with legal services agencies, perhaps with the one agency that got back to me, where for the more complex issues, they reach out to those attorneys. So I'm going to wait to see what I hear back from the other agencies.
Because I'm thinking with our change that we are going to recommend based on Julia's input yesterday, this probably could come out, especially if you're hearing that that's not even happening currently with clinics and groups.
Yeah, I think that the letter we received from those, the joint letter received last time, you know, kind of took a look at the self-help model. For example, my office, where we, the attorneys, supervise our court specialists, their high-level paralegals, but we don't do that on every application. It's only when they have questions, when there are complications, because they're very well trained. And I would say if we sort of follow that model, where we encourage them as part of the ethical rules and responsibilities, is to not perform work that they know they're not competent to perform. It's the same duty that attorneys have, I think, and having these educational requirements. I think we are protecting the consumers.
So I think we're probably going to end up removing that item 3 under the violence prevention, but that's why I just did a strike through to tell me that's where I think we're headed. The next category was child custody and visitation. Included, we identified originally 4 areas and one we weren't sure about that we were going to exclude. And I actually think one of those areas may come out if we're going to include domestic abuse education as both part of the initial education and CLE. And that was any custody actions involving Family Code Section 3044. Under Family Code Section 3044, if either parent is found to have committed an act of domestic abuse, and it doesn't have to be within that child's immediate parental relationship. It could be, I've got a case right now where dad and his new girlfriend got drunk, climbed out of the car and got into a fight on the highway while the kids were in the car. Okay, that invokes the presumptions of 3044. They're pretty significant presumptions. They create a presumption that the abuser should not have physical custody, either sole or joint. should not have legal custody, sole or joint, and at least at the beginning stages creates a presumption that they should have their visitation supervised. So if we're including the domestic abuse training, I would be inclined to actually allow this to be within the scope, or recommend that we allow it to be within the scope, understanding that we're going to include a significant educational component regarding domestic abuse and how that affects custodial issues and how that affects children.
Right. It's all about, I also agree, it's all about training and education requirements,
Right.
and continuing education requirements.
And I think it's critical that our experiential, if you're going to do the family law endorsement, we need to put those people into the clinics for at least some percentage of their hours, and we haven't got there yet.
Or DV agencies, or.
Yeah. The next two are such highly complicated and involved areas, even for practitioners. A lot of attorneys refer these issues out to specialists, and those are cases involving international abduction or Hague Convention issues, or international or interstate custody disputes under the UCCJEA. Those are a highly particularized area of law, and that's where we felt that those should be excluded. The disputed venue issue is we're not fighting whether the case belongs in California. The question is what jurisdiction does it belong in? And
what county?
We initially said excluded, but then we started rethinking it. And I'm actually leaning towards removing this from the list too, Fariba. And the reason I'm having to do one for somebody right now to change venue from Los Angeles to San Luis Obispo County. And I'm looking how easy it is.
So this is not the same as change of venue. Actually, change of venue is very easy.
Okay, so dispute.
This is about where one party resides here with the child, the other party moves to another county and immediately opens a case there. And then it's like, where's venue between the two counties? And the process can get complicated in competing cases. Who serves first? Do the judges talk in the two counties to determine should the case be here or there? So that's where I think it gets complicated. Change of venue is not complicated.
Okay.
Yeah. So I think we should separate the two out. I think it's really jurisdictional and venue disputes, in my opinion, should be excluded. Same as whether it's under the UCCJEA or subject matter jurisdiction or personal jurisdiction or venue. I think that those disputes are too complicated. That's my opinion.
I'll leave that in there. I'm having a hard time thinking of the actual scenario where there's a disputed venue issue. You're not talking about initial venue, you're talking about subsequent venue?
No, you're talking about subsequent venue.
Okay,
We file a motion to change venue. I'm talking about initial jurisdiction issues, initial venue issues. Contested.
So mine is an initial venue issue, but I'm still, the motion is characterized as a motion to change venue.
No, initial venue to me, motion to change venue is when the case exists.
Yeah.
And then one party moves to another county, usually if they're children, is where the children are. I'm talking about when a case is opened and it's opened in the wrong county.
I get it. You're making me think whether I have to restyle my motion, but I think the change of venue applies even on the initial test, as long as I don't file the response.
I disagree. I think that when you open a case and there's just a petition and a summons, your first motion is not to change venue. You know, that takes 6 months to complete. You know that, with the delays and all that. And then you were on FlexCom when that bill came through. Well, when the venue is changed and hasn't been actually completed, the venue keeps, jurisdiction. Anyway, I just think.
And Steve,
I'm sorry, are we doing too much of this?
Listening to you guys, we there's 5 minutes left of the meeting. We have an absolute hard stop because, as you know, we have another one right at 1:30. And I'm wondering if the other members of the working group are finding this useful. If we should just use our last 5 minutes to keep going through this. You did have the document. And I think we need to tee up. I believe we have another meeting on Friday. Is that right?
Yes.
All right. So I think we could tee up what we want to do on Friday. That might be helpful.
Wait, we have a meeting on Friday?
Yes.
Uh-oh. Hold on a second, I'm sorry. All right, I'll stop my share. Then was this helping, Sharon, Dana? Was this helpful or not?
It helped me, and I didn't see anything on the list that I strongly disagreed with, and I very much appreciate all the time you two spent on it.
Yeah.
Yeah, I thought this was really helpful. I'm trying to think from a practical matter. What happens when someone goes to a paraprofessional and they do some of the work and then they're like, oh, I can't do this type of paternity. Are they going to be referring out? What is that kind of like bifurcated case going to look like?
I would expect them, they'd have to refer it out to an attorney to deal with any paternity issues that arise under that subsection. So that's where you've got competing presumptions. You've got biological parent versus nature versus nurture, biological parent versus the parent who's raised the child. The other area, the subsection C, deals with the cases where you're going to recognize more than one parent in a case, or more than two parents in a case. So we're expecting, yeah, you would refer those out.
And Sharon, it could be a situation where you bifurcate the issue and only refer that issue out for determination. And when parentage is established, maybe the rest of it, child support, custody, visitation, are in the included areas. But the seminal issue of parentage is the first thing that has to be handled.
Right.
Because, it results in whether a parent is excluded or included,
Real easy to do with a limited scope, in my opinion.
Mm-hmm.
So the paraprofessionals have got to kind of reach out to their contacts and, refer cases out and, or maybe refer the whole case out. I mean, that's up to them, of course.
Mm-hmm.
So it sounds like on Friday, we should continue going through this. We should plan to continue because I think there was quite a bit more. And then hopefully get into those. I think Linda's slide looked like it was accurate in terms of where maybe you hadn't quite gotten to it yet versus you couldn't agree, right? Or couldn't come up with a recommendation.
We ran out of, we were like 2.5 hours into it. And I think we were just at a point where we're going to come back and revisit these. There were no strong disputes about theirs. It really did kind of lay out easily in terms of practice areas. And the other thing we were looking at, how frequently does this issue arise? Because if I'm focusing on the access to justice issues, some of these issues that come up very rarely, for example, those annulments, those are a rarity, particularly the ones that we excluded. We're not really dramatically affecting access to justice by excluding those because those are not a significant percentage of the family law filings.
Right, we got 12 annulments total in our court in 2019. So, that's not that many.
And most of those are going to be based on the areas that we...
Because people file divorces and they think they're automatically divorced in 6 months and they get remarried. so really,
Been there, done that.
I would hope that every member reads our list and forms an opinion, disagree or agree, ask questions. What does this mean? What does that mean? We didn't get to, originally we had issues, legal issues and tasks. We sort of a little bit mixed them up here, but we can still, for example, task in court representation, is that, are we gonna agree that paraprofessionals should be able to represent persons in court or be a quiet support person? I mean, what are we talking about here? So we still have our list of tasks that Linda typed up, and then what we have here. I really would like us to have a robust conversation and sort of check off things that we all agree, issues and decisions that we have jointly, and then really concentrate on the ones we don't agree.
Yeah. And a lot of when we had footnotes, if you look at there were endnotes, we were making comments we're including all of the support calculation issues. We just want to make sure that there's actually part of the education includes actual training on DISO master, as well as the state, probably we'll focus on the statewide calculator, but the California child support calculator, and actually teaching how to use that in class and kind of issue spotting where the areas where the self-employed people get tricky.
Okay, we'll look forward to resuming on Friday. Thank you.
Thank you.
Thank you,
everybody.
Bye, everybody.